How often in our lives do you get to make a decision that's going to have a profound effect upon someone's life who's a total stranger? How often in your life do you get to decide whether someone obtains justice or walks out of this courtroom feeling that justice wasn't obtained? In our system, when someone is injured through the fault of someone else, the justice that they're entitled to is compensation for the damage that was done to their body, compensation for the injuries, compensation for the pain and discomfort, compensation for the effect upon those activities, compensation for the effect upon the quality and enjoyment of their life. He pulled over, he's getting ready, stopped, the car's completely stopped, he's getting ready to take his seatbelt off. He's turned, and all of a sudden, crash! Metal and glass and plastic exploding. Knocked him back, the seat actually broke. He was then thrown forward into a telephone pole. His body flailed around like the crash dummies we've all seen. The airbags exploded with the smoke and the chemicals that are associated with that. And next thing he remembers, because he was unconscious for a period of time, was somebody knocking on the passenger side window. Couldn't get out of the driver's side. He wakes up stunned and crawls out the passenger side. You will hopefully agree that the most important piece of evidence is what his life was like before, whether he had any problems or pain or discomfort, and what it's like afterwards. And then I'll talk to you about what you can do to give him the justice that he deserves. The defendant chose not to be here. If she's in West Virginia, that's not, there's no reason why she couldn't be here. That's their choice. But that doesn't allow them then to read deposition testimony from a party. He could certainly read it from his own party, from his own client. He could certainly have read it with regard to my client as admission, because it's hearsay. We have people testify. They come into the court. They're sworn in. The jury gets to see them as part of the adversarial process. We don't allow hearsay, out-of-court statements. Even deposition testimony is hearsay unless it comes in for some reason, either as an admission or for cross-examination purposes, for impeachment. So it's not allowed. You don't just read testimony into the record for someone who chose not to be here, but is certainly in the States and could have been here. In addition, there's no relevance. Even if it was admissible hearsay, there's absolutely no relevance as to whether or not the defendant was heard or not heard. She doesn't have a claim. It's not relevant to any issue in the case. I think counsel want to argue that now he's a biomechanical expert, that because his client wasn't injured in the accident, because I think what he's going to try to do, he's going to try to be shrewd with it and say, well, because she's young and she wasn't hurt and my client's 58 years old, therefore the problems are because of his age. It's inappropriate, it's irrelevant, and it doesn't belong in this case. Your verdict has got to be enough compensation to compensate him, as the judge is going to tell you, not only for what's happened in the past for the 4.5 years, but also into the future for his remaining life expectancy. It's tough for him to sit here and listen to these doctors who, hired by the defense, brought in by the defense, say, as Dr. Charles did, he must have had pain before. You remember that? Where is he getting that from? In a courtroom, we decide things based upon evidence. We don't throw things against the wall. It's based upon evidence. And when I asked Dr. Charles, where is it, doctor, in the records? Anywhere in the records, anything you saw, any evidence that he had any pain or discomfort, and the answer is no. So what you should do is, when you get back there, on a daily basis, you should ask yourself, and the time unit argument that I'm making and I'm allowed to make, it's the one argument under the court rules, on a daily basis, what is it worth for this man not to have that pain or discomfort? And all I can ask is, when you come out of that door, after you've rendered your verdict, that you can look Richard and Carol in the eye and know that you did the right thing. Can ask no more. You certainly can expect no less.